Court of the Commonwealth of Australia, Chief Justice Barroso, Chief Justice of the Federal Supreme Court of Brazil, Judge Mezer, representing the Constitutional Court of the French Republic, Judge Viswanathan, representing the Supreme Court of the Republic of India, Judge Arsul Sani, representing the Constitutional Court of the Republic of Indonesia, Judge Nok, representing the Supreme Court of the Republic of Korea, Judge Konovalov, representing the Constitutional Court of the Russian Federation, His Excellency Al Zayed, Vice Minister of Justice of Saudi Arabia, President Ozkaya, President of the Constitutional Court of the Republic of Turkey, President Orkekes, President of the Court of Secession of the Republic of Turkey, President Reid, President of the Supreme Court of the United Kingdom, Lady Chief Justice Carr, Chief Justice of England and Wales, Judge Ntsebeza, representing the African Court of Human and People's Rights, Chief Justice Malaba, Chief Justice of the Republic of Zimbabwe and President of the CCJA, Chief Justice Mapalala, Chief Justice of Eswatini and President of the Southern and Eastern Africa Chief Justices Forum, Judge Benini, representing the Constitutional Court of the Democratic Republic of the People's Republic of Algeria, Justice Murray, representing the Supreme Court of the Republic of Ireland, President Cardoso, President of the Constitutional Court of the Republic of Angola, President El Ribeiro, President of the Constitutional Court of Mozambique, Justice Chong, representing the Supreme Court of Appeal of the Republic of Singapore, esteemed colleagues of the South African judiciary and other judiciaries present here today, Mr. Laraba, Secretary General of the CCJA, Mr. Mufa, UN Resident Coordinator in South Africa, Mr. D'Souza Godoy Guilherme, representative of UNESCO, Mr. Musindo, Director of ILO in South Africa, Mr. Filtane, representing Juta Publishers, members of the legal fraternity and academia, members of the media, members of the public following these proceedings via media platforms, esteemed guests, ladies and gentlemen, good morning. It's a muted good morning. Good morning. On behalf of the judiciary of the Republic of South Africa, and indeed on behalf of a nation reborn through justice and the rule of law, it is my profound honor and privilege to extend a warm, heartfelt Africa welcome to you all. We gather here today in this vibrant corner of the African continent, not merely as representatives of our individual nations, but as guardians of a shared global covenant, the unwavering pursuit of justice under the law. The ancient wisdom of our continent teaches us that the philosophy of Ubuntu, Umuntu ngumuntu ngabantu, I am because we are, my humanity is inextricably tied to yours, remains relevant. This summit embodies that very principle. The challenges we face, from ensuring equal access to justice, to navigating the digital frontier, to upholding the dignity of every individual, are not confined by borders. They are human challenges, and they demand collective wisdom-driven solutions. We are particularly honored to welcome our distinguished guests from across the G20 nations and our special invitees, including the pivotal continental bodies of Africa. Your presence here is a powerful testament to a truth we hold self-evident, that the voice of the Global South is not a whisper from the periphery, but is an essential resonant chord in the symphony of global jurisprudence. Africa is not a subject of history. It is a dynamic architect of its future, rich with innovation, wisdom, and a relentless spirit of progress. Together, today, we gather under the guiding theme, Justice in a Time of Change, Independence, Innovation, and Cooperation. A vital call to action that invites us to address the evolving contexts in the judiciary landscape, domestically and globally, while reinforcing our commitment to accessibility, fairness, forward-thinking solutions, and cooperation across borders. Independence, innovation, and cooperation are not isolated ideals, but mutually reinforcing. By safeguarding independence, our courts remain trusted guardians of rights. By embracing innovation, we improve how we serve the public. And by fostering cooperation, we extend the reach of justice beyond our own jurisdictions. This summit embodies all three values. In these 2 days, we will have robust discussions reflecting these themes, whether it is preserving judicial independence in a challenging world, balancing technological advancement with fundamental freedoms, addressing climate change through judicial collaboration, or strengthening our united front against cross-border crime. In each session, we will learn from one another and refine our common vision for the evolution of our respective judicial systems. Distinguished colleagues, the stakes could not be higher. In every country, people rely on the courts for fairness and certainty. If independence is compromised, so too is the protection of their rights. If we fail to cooperate, if we lag in innovation, their access to timely justice suffers. If we fail to cooperate, injustices can spread unchecked. Let this summit be a beacon of hope, showing the world that the guardians of justice are neither idle nor divided in the face of change, but active, united, and resolute. This J20 summit provides a sacred space for dialogue, a forge where we can temper the steel of our legal frameworks in the fire of shared experience. It is an opportunity to learn from one another's triumphs and tribulations, to find common ground in our diverse approaches, and to strengthen the bonds of mutual respect and cooperation that unite our judiciaries. Our retired Constitutional Court Justice, Justice Albie Sachs, once remarked, and I quote him, "Rights are not gifts from the state, they are claims that can be made against it," I close quotes. These words capture the essence of why we are here. They remind us that courts exist not as generous benefactors, but as guardians of enforceable rights. And they press us to ensure that our innovation and cooperation across all our jurisdictions never lose sight of the people whose dignity depends on the strength of our courts. Let us use this time to build those bridges. Let us speak with candor, listen with empathy, and deliberate with the wisdom of our offices demand and our citizens deserve. It is our sincerest hope that the discussions held within these halls will be rigorous, that the partnership forged will be enduring, and that the outcomes will leave a lasting legacy, not just in law reports, but in the lives of the people we are all sworn to serve. On behalf of the South African judiciary, I once again thank you all for being here and formally welcome you to the J20 Summit. I'm confident that our time together will strengthen our resolve and spark fresh ideas to fortify the rule of law in each of our nations. As we embark on our discussions, let us remember that the principles of independence, innovation, and cooperation are not goals in themselves, but means to better serve our citizens whose rights depend on our vigilance. You are most welcome. You are at home. In many ways, the ideals envisioned in this summit find their clearest expression in the leadership of our own Chief Justice, a true leader who stewards our judiciary with vision, integrity, and courage. Chief Justice Maya has long been recognized as a pioneer, not only the first woman to ascend to the highest judicial office in our land, but also a jurist whose career has consistently expanded the horizons of justice. From her early years on the bench to her historic leadership of the Supreme Court of Appeal and now as Chief Justice of the Republic, she has shown us what it means to marry independence with compassion, innovation with prudence, and cooperation with resolve. Her jurisprudence, particularly in advancing gender equality and broadening access to justice, has given life to the Constitution's promise that rights belong to all, regardless of power or position. A daughter of the soil, a guardian of justice, from the rolling hills of the Eastern Cape to the highest seat of justice, the journey of Chief Justice Mandisa Maya is a profoundly African story of brilliance, resilience, and transformative power. She is not merely a woman of firsts, she is a living testament to the promise of a new dawn. A pioneer who has woven the rich threads of a heritage into the very fabric of South Africa's judiciary. Her path was charted with a quiet determination that speaks of Ubuntu and unyielding intellect that has consistently shattered ceilings. Distinguishing herself from the outset, she was among the youngest women ever to be appointed to the bench, a groundbreaking beginning that foreshadowed her historic ascent. From this foundation, she rose like the baobab, strong, deeply rooted, and offering shelter to others. She became the first woman president of the Supreme Court of Appeal, the first female deputy chief justice, and now the inaugural woman to lead South Africa's judiciary as chief justice. Her career is not merely a personal triumph, but a beacon for every young girl across the continent who dares to dream beyond the confines of expectations. Hers is an illustrious career, forging a legacy of principle and progress. Chief Justice Maya's career is a masterclass in judicial excellence and visionary leadership. After her early appointment, she quickly distinguished herself through an incisive legal mind and an unwavering commitment to constitutional justice. Her tenure at the Supreme Court of Appeal was marked by landmark judgments that advanced fundamental principles, particularly in the crucial areas of gender equality and access to justice for all. As president of the SCA, she revitalized the court's efficiency and fostered a spirit of collegiality, earning widespread respect for her ability to unite diverse judicial voices around a shared vision of fairness and integrity. Her elevation to Deputy Chief Justice in 2022 cemented her reputation as a unifying force and a reformer. In this role, she championed critical institutional reforms, driving the modernization of court processes and tirelessly expanding access to justice for marginalized and rural communities. Her leadership was instrumental in steering the judiciary towards greater independence. Notably, her powerful advocacy for gender parity catalyzed a significant increase in the appointment of women judges, ensuring the bench finally begins to reflect the beautiful diversity of the nation itself. As Chief Justice, she has embraced her role as the guardian of judicial independence with fervor and profound purpose. Her announcement of a groundbreaking sexual harassment policy on behalf of the judiciary stands as a testament to her commitment to creating an institution that is not merely only independent, but also safe, inclusive, and dignified. Hailed as a watershed moment, this policy underscores a fundamental truth. Justice cannot thrive where human dignity is compromised. She is rooted in community and was elevated by her excellence. She was born in the village of Solo in the province of the Eastern Cape. Her epic journey is powered by an academic arsenal that rivals her practical achievements. A BProc degree from the University of Transkei, an LLB from the University of Natal, and an LLM from Duke University in the United States. Her transformative impact has been recognized by no fewer than 4 honorary doctorates, each celebrating her monumental contributions to jurisprudence and gender equality. A devoted mother and wife, Chief Justice Maya carries the spirit of Africa with her, the wisdom of the elder, the courage of the pioneer, and the heart of a nation. She has not merely climbed the legal ladder, she has dismantled its narrow confines and rebuilt it stronger, more inclusive, and more just for generations to come. Her jurisprudence continues to shape South Africa's legal landscape, balancing precedent with progressive interpretations that ensure our Constitution remains a living, breathing instrument for societal change. Through her judgments, her mentorship, and her towering leadership, Chief Justice Maya demonstrates daily that the law is more than a tool for adjudication. It is a vehicle for healing, for empowerment, and for building a more perfect union. She is truly a lioness of justice, and her roar is the sound of progress itself. Ladies and gentlemen, it is my profound honor to introduce to you my leader, our leader, the Chief Justice of the Republic of South Africa, Chief Justice Mandisa Maya.
Thank you for those kind words, Deputy Chief Justice Mlambo. Chief Justice of the Federal Supreme Court of Brazil, Honorable Chief Justice Barroso, Chief Justice of the Republic of Zimbabwe and President of the Conference of Constitutional Jurisdictions of Africa, Honorable Chief Justice Malaba, Chief Justice of the Supreme Court of Appeal of Botswana, Honorable Chief Justice Ketlohetswe, the Chief Justice of the Kingdom of Eswatini and President of the Southern and Eastern Africa Chief Justice Forum, Honorable Chief Justice Mapalala, the President of the Constitutional Council of Mozambique, Honorable Justice Ribeiro, President of the Constitutional Court of the Republic of Turkey, Honorable President Ozkaya, President of the Court of Cassation of the Republic of Turkey, Honorable President Okerkez. He complimented me last night that I pronounced the name perfectly and now I'm mangling it. Okerkez. President of the Supreme Court of the United Kingdom, Right Honorable Lord Reid. Chief Justice of England and Wales, Right Honorable Lady Chief Justice Carr. Chief Justice President of the Constitutional Court of the Republic of Angola, Honorable President Cardoso, Deputy Chief Justice of the Republic of South Africa, Honorable Deputy Chief Justice Mlambo, President of the Supreme Court of Appeal of the Republic of South Africa, President Molemela, Representative of the High Court of the Commonwealth of Australia, Honorable Justice Jago, representative of the Constitutional Court of the French Republic, Honorable Justice Metsat, representatives of the Supreme Court of the Republic of India, Honorable Justices Vis Vanathan and Bishnoi, representative of the Constitutional Court of the Republic of Indonesia, Honorable Justice Sani, representatives of the Supreme Court of the Republic of Korea, Honorable Justices No and Suk, representative of the Constitutional Court of the Russian Federation, Honorable Justice Konovalov, representative of the African Court for Human and People's Rights, Honorable Judge Nsebeza, representative of the Constitutional Court of the Democratic Republic of the People's Republic of Algeria, Honorable Justice Benini, representative of the Supreme Court of the Kingdom of Saudi Arabia, Ambassador Al-Habi, representative of the Supreme Court of the Republic of Ireland, Honorable Justice Murray, representative of the Supreme Court of Appeal of the Republic of Singapore, Honorable Justice Chong, Honorable Justices of the Constitutional Court and Supreme Court of Appeal of the Republic of South Africa and from other jurisdictions, Judges President, Judges, Regional Court Presidents, and Chief Magistrates of the South African Judiciary and other judiciaries present here today, Secretary General of the Conference of the Constitutional Jurisdictions of Africa, Mr. Laraba, United Nations Resident Coordinator in South Africa, Mr. Mufu, representative of the United Nations Educational, Scientific and Cultural Organization, Mr. Guilherme, Director of the International Labour Organization in South Africa, Mr. Musindo, members of the legal fraternity and academia, representatives from various government departments and Chapter 9 institutions, representatives of civil organizations in South Africa, members of the media, distinguished guests, good morning. Good morning. Thank you. It's a special privilege to deliver this opening address at this August gathering of the heads of the Supreme and Constitutional Courts of the Group 20 members, and to welcome you to the 2025 J20 Summit. On behalf of the Judiciary of the Republic of South Africa, I convey our warm African greetings and deep appreciation for your attendance and participation in this critical dialogue. As South Africa prepares to hand over the baton of the Group 20 presidency in November, after assuming the mantle she took over from Brazil in December 2024, a first for the African continent, we, the South African judiciary, are profoundly honored to host a gathering of this magnitude. It is by all accounts the inaugural J20 summit of the constitutional and Supreme Court leaders in Africa, not just South Africa. We are most heartened and humbled by the presence of so many countries, colleagues who have traveled long distances from all corners of the world to support this event. We are most grateful too to our colleagues from this continent, from the uppermost tip of Africa, Algeria, all the way down to our immediate neighbor, Zimbabwe, just across our northern borders. And the African Court of Human and People's Rights is part of this group. It cannot be overstated that South Africa carries the responsibility of hosting this summit, not just for herself, but for the whole of Africa, her people, and their hope for a just future. This summit is for us more than a mere diplomatic courtesy. It is a historical convergence, a deliberate and necessary assembly of the judicial guardians of the free world at a time when the pillars of democracy and human dignity are under unprecedented strain, and the very foundations of justice are being tested and reshaped by global change. In the grand tapestry of human progress, there are moments that demand not just reflection, but resolution, moments that call upon the stewards of justice to step forward and affirm power of the law, the enduring power of the law, in an imperiled world. This is one of those moments. The judiciary has always been the sentinel of society, the neutral ground upon which the powerful are held to account and the vulnerable find their voice. We are the custodians of the social contract, entrusted with the sacred duty to interpret not only the letter of the law, but also its spirit, the timeless pursuit of fairness, equity, and truth. And on our watch, the instruments of justice upon which humanity relies to maintain social order and prosperity of her nations are being most ruthlessly tested by a new and alien class of challenges that are amorphous, borderless, and are evolving at a pace that often outstrips the deliberate cadence of the law. It is now not so unusual for our courtrooms to adjudicate cases that involve interests straddling continents. Our court rolls abound with disputes born in the digital realm and difficult social dysfunction, and our precedents must wrestle realities which those who came before us could never have imagined. This meeting stands to show an inexorable evolution in global governance and the recognition that the judiciary is an indispensable pillar in addressing the most pressing challenges of our time. Our forum, the Judiciary 20, is an integral part of the Group 20 and represents the third branch of state in this important forum for international economic cooperation. South Africa is quite fortunate because we build upon the visionary foundation laid by the masterfully curated Brazilian J20 presidency in 2024, which rounded up judicial leaders from around the world to deliberate on social justice, environmental sustainability, and the digital transformation of justice with seeming effortlessness. The South African delegation, which attended the Rio Summit, spoke very highly of their experience there. We are therefore very pleased to have the Brazilian delegation led by Chief Justice Barroso at this event, and we look forward to their contributions to the discussions. Their legacy, which is meticulously documented in their official portal, provides a valuable framework for our continued dialogue and is a powerful model for how the judiciary can contribute to the G20's mission of fostering global stability and sustainable development. It is a bonus that we can tap into that treasure trove physically in these 2 days. The existence of the J20, which was pioneered in 2018 and has recently been revitalized under Brazil's leadership, signals a critical understanding that economic policies, climate agreements, and digital frameworks, and a host of other issues that drive the modern world are ultimately upheld, interpreted, and given force by the rule of law. We are the engagement group that ensures that the commitments made by the nations within the G20 are anchored in legal principles and accessible justice. Through the exchange of ideas and initiatives on contemporary legal topics, we transform abstract goals into tangible rights and protections for citizens worldwide, thereby strengthening the very fabric of multilateralism. J20 Rio de Janeiro powerfully demonstrated this, moving beyond discussion to forge concrete strategies for enhancing judicial accessibility, confronting the climate crisis through litigation, and harnessing technology for efficient justice, all while steadfastly promoting citizenship and social inclusion. We hope to achieve the same results here. The journey to the summit started with a simple request to our peers who are here in flesh today for a special virtual session in July. This would become a remarkable exercise in international coordination and diplomatic ingenuity, organizing a global gathering of judicial leaders from diverse time zones, including the United Kingdom, India, Russia, Turkey, France, Indonesia, Australia, and Brazil, required meticulous planning to accommodate their busy schedules and ensure meaningful participation. The use of technology was pivotal. Video conferencing and virtual collaboration tools facilitated real-time interaction, while advanced scheduling considered temporal dispensation to minimize coordination costs. The inclusive approach to topic drafting, where each participating country contributed agenda items, fostered a sense of shared ownership and alignment with global judicial priorities. This process mirrored the principles of collaborative input and consensus building seen in successful virtual strategic planning sessions, where advanced work and stakeholder engagement are critical for productivity and focus. The acceptance of the invitation by all these nations shows that their firm commitment to strengthening judicial cooperation and addressing transnational challenges such as human rights, rule of law, and sustainable development. Each country brings unique perspectives to the table, and that initial participatory topic drafting phase not only enriched the agenda, but also built trust and cohesion among the participants. The session demonstrated how virtual platforms can transcend geographical barriers to foster dialogue. It set an important precedent for future virtual judicial collaborations, highlighting the potential of technology to enhance international diplomacy in an increasingly interconnected world. Our theme, Justice in a Time of Change, Independence, Innovation, and Cooperation, captures the essence of the current judicial epoch. We have gathered here not merely as observers of this change, but as participants entrusted with the sacred duty of ensuring that justice remains a compass guiding societies through turbulence and transformation. Therefore, our role extends far beyond mere deliberation. We are the architects of a legal infrastructure that supports a more resilient, inclusive, and equitable global future. The documents produced under Brazil's presidency serve as our compass, guiding us to leverage our unique constitutional mandates to implement and oversee policies that secure sustainable development and protect human dignity. As we reflect on this heritage, we must embrace our collective responsibility with courage and clarity, engage in our discussions boldly. We must strengthen our collaborations and make purposeful resolutions to ensure that the voice of the global judiciary continues to resonate powerfully within the G20, and most importantly, in the lives of the people we serve. This summit will examine the evolving demands on justice systems in a time of political, technological, environmental, and legal transformation, and explore how courts can uphold independence, embrace innovation, and enhance international judicial cooperation. We will, over the next 2 days, confront the question of how we uphold the enduring principles of justice in a world where everything else seems to be shifting. And as we do this, we must be reminded that our independence will keep us steadfast, with the assurance that the judiciary will remain impartial and uphold the rule of law. I will briefly touch upon some of the broad topics that will be discussed today and tomorrow, and how they have manifested and have been addressed in South Africa. I start with judicial independence and accountability, preserving the rule of law, and reinforcing judicial security in an evolving global landscape, which will be addressed in session 1 of the program. As one of the basic structures and premises of the new constitutional text, the South African Constitution establishes a democracy based on the supremacy of the Constitution, protected by an independent judiciary. This includes institutional independence, which can only be achieved if the judiciary enjoys structural, including financial, operational, and perceived independence. Judicial independence is widely understood to be protected by 3 fundamental aspects: security of tenure, financial independence, and administrative control. 3 characteristics which are meant to support the judiciary as an institution as well as the independence of individual judges from undue external influence. Marking a significant departure from our painful past as a country, the advent of the constitutional dispensation in South Africa introduced a new kind of a judicial system, a judiciary that is independent from other arms of government and is accountable only to the Constitution and the law, which it must apply impartially and without fear, favor, or prejudice. Judicial independence, which has two components, individual independence and institutional independence, respectively, referring to the ability of judicial officers to act independently and impartially, and the existence of structures and guarantees to protect our courts and judicial officers from interference by other branches of government, is thus of utmost importance for the courts to effectively play their crucial role and conserve an impartial judicial process. Under the historical governance system of the South African judiciary, the court administration of both the superior courts and the magistracy was controlled by the executive. In 2009, the then Chief Justice, lobbied the executive and began a series of ambitious reforms which were aimed at securing full independence of South Africa's judiciary. In that exercise, the Office of the Chief Justice was established as a national department through a presidential proclamation to provide support to the Chief Justice as the leader of the judiciary and advance the independence and effectiveness of the judiciary. However, this did not bring about an efficient, effective, and accessible justice system because full independence was not achieved. The executive still maintains control over the budget and financial management of the judiciary, which is the heart of the power and ability to meaningfully run anything at all. The judiciary has limited control over key components of court administration, such as the establishment of magistrates' courts, the appointment of magistrates and support staff, security and information technology, with many of our court buildings, especially the magistrates' courts, which serve as courts of first conduct, in poor condition due to years of underfunding and neglect. These systemic challenges adversely affect the lives of the communities we serve and ultimately impede the delivery of justice. As a result of undercapacity and an exponential surge in litigation, courts are faced with heavy backlogs, which result in undue delays of cases. For someone fighting an unfair dismissal or a community, or a community trying to protect their land rights, these delays are not merely frustrating, they are a denial of basic human rights. When funding is misused or delayed, our courts and the people who rely on them are left vulnerable, and the constitutional promise of justice is compromised. The consequences of these challenges are also often deadly. An example of this is the tragic killing of Dingalomoya Chinzo, a witness in a murder trial who was gunned down in broad daylight inside the Wynberg Magistrates Court in Cape Town just in April. There are other examples. Across the country, our courtrooms, entrances, and parking areas often lack a visible security presence, and where security exists, it is frequently rated as poor. In the recent Wynberg incident, private security guards were stationed at the entrance, but the metal detector was not working on that day. This fatality and many others that are occurring in court precincts in our country, especially in the Western Cape, with alarming frequency, highlights the urgent need for meaningful improvements to our court infrastructure, without which the safety of the communities who depend on our courts and the very judicial officers and court staff who are ironically expected to dispense justice in those conditions hangs in the balance. Administrative autonomy for the judiciary is therefore critical to allow judges and magistrates to determine tailored safety protocols suited to court-specific needs and manage infrastructure and resources with greater efficiency and effectiveness. During a judges and magistrates conference held in December 2023, themed towards a single, effective, and fully independent judiciary, the South African judiciary unequivocally called for urgent reforms in the institution, chief of which is full judicial independence. The conference closely examined whether there is sufficient protection and support for judicial independence in South Africa. Among the resolutions it adopted, the judiciary called for a single judiciary encompassing all superior courts and lower courts, as well as for full control over their own administration, budget, and operational functions. It is only on 6 June 2025, a day which marked a watershed moment in the South African judiciary's 15-year-long battle for its autonomy, that the executive, led by the president of the country, with the judiciary, to discuss the long overdue reforms towards the attainment of the independence of this neglected arm of state. That meeting highlighted the importance of cooperation among the branches of government, whilst maintaining a delicate balance and ensuring that they do not overstep the relevant boundaries and encroach into each other's terrain, and proved that it is possible under the principle of separation of powers for the arms of state to support one another as they must to uphold the Constitution. It gives me great delight to announce that the South African judiciary is finally on the path to full institutional independence, and that the technical teams of the executive and the judiciary are working feverishly to bring this constitutional imperative to reality. The other side of the coin, of course, is that while the judiciary is regarded as the guardian of the rule of law and democracy, and the protection of its independence is paramount for it to fulfill its constitutional functions and duties, judicial independence does not mean that the institution stands above scrutiny and is exempted from accountability. The questions who will guard the guards themselves and how the guardians should be guarded are necessary in any constitutional democracy, and it is essential, therefore, that in every judicial system, accountability mechanisms are put in place to ensure that judges and magistrates remain personally and institutionally accountable for their actions and decisions in compliance with constitutional and other legal standards. Judicial accountability in South Africa operates primarily through two mechanisms: the appeal and review process, which allows higher courts to review and overturn decisions of the lower courts, and a formal judicial conduct process led by the Judicial Service Commission, established by the Constitution and involving the President to address gross misconduct, incapacity, or gross incompetence, which may result in a judge's removal from office. Additional to these measures, the Chief Justice accounts to the public by presenting the Judiciary Annual Report on the judiciary's performance and challenges. The Bangalow Principles of Judicial Conduct, which were developed to promote and strengthen judicial accountability in the judiciaries of the United Nations member states, serves as a guide for the regulation of the South African judiciary's conduct and the promotion of ethical behavior within its ranks. And we have used these instruments in finally formulating the sexual harassment policy, to which Deputy Chief Justice Mlambo alluded earlier, a few weeks ago, for which there had long been a clamor. Session 2 will deal with the burning subject of artificial intelligence, the key pillar of the second phase of the fourth industrial revolution, which has overtaken almost all aspects of human life and presents unimaginable opportunities for the human race as well as the justice system. We are cautioned to approach this transformation with a balanced perspective, one that enthusiastically acknowledges AI's profound potential to enhance efficiency, reduce crippling backlogs, and lower the cost of legal services. It has been quite exciting to discover that tools for legal research, transcription, and automated administrative functions can free judges to focus on the core human element of adjudication. But while the use of this tool has the potential to be a powerful ally in legal practice, recent cases have also revealed how its misuse can undermine both professional ethics and the integrity of our jurisprudence. This was illustrated in the Northbound case, in which the High Court discovered while drafting its judgment that 2 cases cited in the applicant's heads of argument actually did not exist. When invited to explain, junior counsel initially claimed that an incorrect version of the heads had been filed, attributing the problem to short-form citations and filing a substituted version. However, opposing counsel pointed out that even the corrected version still contained 2 non-existent authorities and questioned whether some of the existing authorities were properly applied. Pressed by the court on whether the spurious citations were the product of artificial intelligence hallucinations, counsel considered that they appeared to be so, and explained that severe time pressure, the urgency of the matter, and the withdrawal of the original junior counsel had led him to use an online tool called Legal Genius, which claimed to be trained on South African judgments and legislation, but nonetheless generated fabricated references. Fabricated citations undermine the credibility of counsel and the profession, breach the ethical duty of care owed to clients and the court, and threaten the integrity of our jurisprudence by polluting written submissions with fictitious authority. Needless to say, while AI tools can assist research, they are no substitute for independent legal reasoning and rigorous verification of resources. Lawyers who abdicate their professional responsibility to technology risk harming their clients and eroding the trust on which the legal system depends. Perhaps most striking was the case of Mavundla versus MEC, Department of Cooperative Government and Traditional Affairs, in which the court found out that only 2 of the 9 cited cases actually existed, and the judge dismissed the application with punitive costs and referred the matter to the Legal Practice Council. These cases are warning signs that the legal profession must engage proactively with the ethical, procedural, and evidentiary challenges posed by AI. Clearly, if we do not shape the future of AI in law, it will shape us and do so mercilessly. Hearteningly, as South Africa stands at the crossroads of digital transformation, the government has begun laying the groundwork for a national approach to artificial intelligence. On 5 April 2024, our Department of Communications and Digital Technologies published the Artificial Intelligence Planning Discussion Document, which is a foundational text that outlines the state's vision for integrating AI into public and private sectors and proposes the establishment of an AI expert group to work alongside government in shaping a national AI policy with a regulatory framework expected to unfold in the next 2 years. This initiative signals the intent to develop legal principles and governance instruments that ensure that AI is used ethically and responsibly. In August 2024, the National Artificial Intelligence Policy Framework was introduced as the first formal steps towards an AI Act. It emphasizes the need for inclusive, safe, and public interest-driven AI applications, while also calling for investment in AI literacy, local innovation, and improved public data systems to enhance e-government services. It will be interesting to hear how these challenges have manifested and are dealt with in other jurisdictions. Session 3 is concerned with the climate change justice. As we all know, judiciaries across the world are being called upon to adjudicate complex climate cases, often balancing environmental rights with economic development, state obligations, and intergenerational justice. This requires judges to engage in further learning on environmental matters. In a recently launched collection of essays celebrating the 10th anniversary of the South African Judicial Education Institute. Its Chief Executive Officer, Dr. Mushweu, and her co-author, Mr. Wabunoha, state that, I quote, "The subject of environmental management is complex and has scientific, technological, economic, social, and equity imperatives that require continuous provision of training to judicial officers, especially with regard to the ever-evolving environmental science. Successful implementation of the law depends on a judiciary that is well equipped to adjudicate matters they preside over," close quote. Judicial education must, of course, keep pace with developments in climate change science and policy. The stakes for ecosystems, for communities, and for future generations could not be higher. Investing in continuous, contextually relevant judicial training is no longer optional, it's an imperative. But no court can address this challenge in isolation. Climate justice demands transnational legal dialogue, the sharing of jurisprudence, and perhaps even joint frameworks for accountability and enforcement. In session 3, our colleagues from France, Australia, Indonesia, and Mozambique will no doubt provide us with helpful pointers for the increasing volume of climate-related litigation and the need for coherent judicial collaboration across borders. This session, therefore, is essential, not as a theoretical exercise, but as a space to equip our cause to act, to innovate, and to reinforce one another. As the climate crisis deepens, so must our resolve as jurists to deliver climate justice fairly, boldly, and collaboratively. The last 2 years have marked a turning point in the evolution of global climate jurisprudence, and 3 landmark advisory opinions delivered by the world's most respected international courts have laid a new legal foundation for climate accountability and state obligations, and I'm sure we'll hear all about those when we get to that session. The last session is concerned with combating cybercrime. In executing its mandate, the South African judicial system is reliant on digital infrastructure, for example, the court online platform and emails for important reasons such as case management, efficient communication, and enhanced public access to legal services. The digitization of court operations through the integration of digital technologies has improved procedural efficiency and arguably access to courts. This transformation was notably accelerated by the COVID-19 pandemic, which necessitated the adoption of virtual hearings and other remote legal processes. However, this digital transformation encompasses significant risks in relation to cybersecurity, for example, ransomware attacks, unauthorized access to sensitive judicial information, and data breaches. Fortunately, South Africa has a robust legal framework governing cybersecurity and aimed at combating cybercrime. Legislation such as the Cybercrimes Act, the Protection of Personal Information Act, and Electronic Communications and Transactions Act. As an institution, the Office of the Chief Justice is responsible for the administration of superior courts and is a vital role player in overseeing the digital transformation of judicial processes. The Department of Justice and Constitutional Development also have a responsibility for broader justice sector IT systems and must ensure compliance with cybersecurity legislation. This equips the judiciary with the necessary tools to detect, investigate, and protect our institutions. Although the shift towards digital systems have had significant advantages, it has also introduced new layers of complexity and potential security gaps that require attentive oversight. Given the inherently sensitive nature of the judiciary's infrastructure, it is imperative to implement robust cybersecurity strategies to safeguard the judiciary's electronic and cyber infrastructure from malicious threats. As the judiciary becomes digitized, its vulnerability to cyber attacks grows. In light of this, there is a need to ensure a high standard of cybersecurity, not only in relation to the protection of data, but in preserving the integrity of the justice system and maintaining public confidence in its operations. Therefore, judicial bodies must adopt a proactive and strategic approach to mitigating risks by implementing rigorous information and data protection measures. Another common challenge is the lack of, or rather limited, adequate technological infrastructure within the justice systems, including the availability of computer equipment, reliable and fast internet access, and secure data storage systems. Without a strong electronic and cyber infrastructure, achieving successful implementation of electronic processes can be challenging, and it will be interesting to hear how other jurisdictions are coping with these challenges. The alarming growth rate of cybersecurity threats, which also affect judicial institutions, makes clear that there's an urgent need for a comprehensive and proactive approach to digital security and implementation of robust technical safeguards and organizational practices that collectively strengthen the justice system's digital infrastructure. The measures which are recommended to secure remote connections and protect sensitive data during transmission, such as virtual private networks and multi-factor authentication, touted as significantly reducing the risk of unauthorized access, align with South Africa's broader legal obligations under the Protection of Personal Information Act and the other legislation in that space. We look forward to the exchange of experiences and solutions in this area as well. As I conclude, please allow me to extend in advance our gratitude to the distinguished facilitators of the summit sessions. Their role guiding our discussions with expertise, patience, and insightful direction is the engine of our dialogue. The complex and critical topics on our agenda demand not only knowledge but also skillful leadership to navigate diverse perspectives, and we are confident that their stewardship will ensure discussions that are productive and enlightening and pave the way for meaningful outcomes. Our appreciation extends to the esteemed panel members who have dedicated significant time and intellectual rigor to prepare for these discussions. We have no doubt that their contributions on the various topics will broaden our understanding and add substantial depth to the collective wisdom assembled here in South Africa today. We also thank every nation represented here. The diverse perspectives from every corner of the world will certainly enrich our discussions immeasurably and remind us that our collective strength lies in our unity and our willingness to listen, learn, and collaborate towards a common future. The arc of the moral universe is long, but it bends towards justice only when we possess the courage to bend it. I trust that we will use the summit to reaffirm our core vows to judicial independence as a shield against coercion, transparency as the antidote for distrust, and unwavering accountability to the people we serve. We have the power to shape the next chapter of global jurisprudence. Let us write one that future generations will look upon with gratitude and pride, a chapter defined by courage, innovation, and an unshakable faith in the enduring power of justice. Thank you.
Thank you very much, Chief Justice. And could I request another round of applause, please, for the CJ? What's going to happen now is I just need to make one correction to, I think, in the protocol list, we should have acknowledged as head of the delegation of Algeria, Justice Abbas Amar. Please accept our apologies for that. And then you would have worked out already the channels for interpretation. Number 1 is for English, number 2 is for French, number 3 is for Portuguese, number 4 is for Turkish, number 5 is Arabia, and number 6 is Korean. Thank you very much. And then before I direct the photo shoot process, I just need to introduce the session facilitators because there will be no one to introduce them. I'll start with the session facilitator for the first session after this, the photo shoot. That is Justice Leona Theron from South Africa. Could I ask her to stand up, please? Justice Theron has smashed through glass ceilings during her career. She began a judicial career in 1999 when she was appointed judge of the KwaZulu-Natal Division of the High Court of South Africa. After serving the High Court for 11 years, she was appointed to the Supreme Court of Appeal, and in 2017, she was appointed to the Constitutional Court. The next facilitator for today is Justice Stephen Chong from Singapore. Could I ask Justice Chong to stand up? Yes, thank you. Justice Chong was appointed Judge of Appeal of the Supreme Court in 2017. He served in various roles in the legal profession. Justice Chong was appointed Judicial Commissioner of the Supreme Court on 1 October 2009 and subsequently a Judge of the High Court in June 2010. The next session facilitator is the head of delegation of Algeria, Justice Abbas Amar. Could I ask Justice Amar to stand up, please? Yeah. Justice Amar is the judge of the Constitutional Court in Algeria. He is also a professor in public law. We expect to hear a lot from Justice Amar and his delegation when we deal with AI, how they've navigated transcription services, because we've read about what they've done in that field. The next session facilitator I want to introduce is Justice No Gyonpil from Korea. Justice No is the judge of the Supreme Court in Korea since August 2024. He began his judicial career in 1997 at the Seoul District Court and subsequently served in multiple district and branch courts. He was appointed Justice of the Supreme Court in August 2024, following his tenure as the Chief Presiding Judge of the Suwon High Court. Justice No has established himself as a recognized authority in public law and administrative jurisprudence. Those are the session facilitators I thought I must introduce beforehand. What's going to happen now, we're going to have a photo shoot, and the photo shoot will happen in 3 phases. It involves the international delegations. So without wasting any time, I would request all our international guests to move outside. And then outside, there are protocol officers who are going to direct them how the 3 photos are going to be taken. Could I ask that we do that? And then maybe before you stand up, we have not arranged any tea because we were mindful of time. So when the program continues, when you really feel the urge to grab a cup of tea, you can quietly walk out. There are serving stations outside. You grab your cup and you come back. Thank you very much. So could I request our international guests then to move outside, please?